Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Getting a court summons can be terrifying. Someone hands you a stack of papers, or you find them taped to your door, and your heart just drops. The absolute worst thing you can do in this situation is ignore it. If you throw it away or pretend it doesn't exist, the court will likely issue something called a default judgment against you, which means you automatically lose the case without ever getting to tell your side of the story. So, your first step is to take a deep breath and carefully read everything. You'll typically have two main documents, the summons and the complaint. The summons is the official notice from the court telling you that you've been sued and that you have a limited time to respond. The complaint is the document from the other party, called the plaintiff, explaining why they are suing you. As you read, look for three key pieces of information: who is suing you, what court the case is in, and most importantly, the deadline to respond. This deadline is critical. It's usually a specific number of days, often 20 or 30, from the day you were served. Your main task is to prepare and file a formal response, which is most often a document called an answer. In your answer, you must respond to each numbered paragraph in the complaint. For each claim the plaintiff makes, you will typically state that you admit it if it's true, deny it if it's false, or state that you lack sufficient information to either admit or deny if you don't know. It's crucial to be truthful. In addition to responding to their claims, you may also need to include what are called affirmative defenses. These are legal arguments that could defeat the plaintiff's claim, even if their allegations are true. For example, an affirmative defense could be that the statute of limitations has expired, meaning they waited too long to sue you, or that you already paid the debt they're claiming you owe. Once your answer is written, you can't just send it to the plaintiff. You must follow a two-step process. First, you have to file the original document with the court clerk listed on the summons, which usually involves taking it to the courthouse and paying a filing fee. Second, you must serve a copy of your answer on the plaintiff or their attorney, which means you have to formally deliver it to them according to court rules, often by mail. Now, here is the most important piece of advice: this entire process is complex, and the rules can be very strict. This video is for informational purposes only and is not legal advice. You should seriously consider consulting with an attorney as soon as you are served. A lawyer can properly advise you, help you draft a strong answer, identify all possible defenses, and ensure everything is filed and served correctly. If you cannot afford an attorney, search online for your local legal aid society or your state's bar association, as they often have resources or referral programs for low-cost legal help. Taking this seriously and acting quickly is your best defense. Thank you so much for watching. If you found this information helpful, please give this video a thumbs up and subscribe to the channel for more guides on navigating complex situations.